Thank you. Judge, before I begin my questioning, I'd like to point out for the record, there are 32,000 pages of documents, but I would guess 31,000 pages of those have nothing to do with what you've written, nothing to do with what you said. They're agency documents. So the implication should not be left here that anybody has questioned you on even a remotely large part of those 32,000 pages. All you've been questioned on so far, and all I think the Senator was making the point about, is that we're trying to figure out, as you said, how you would rule. We don't want to know how you rule on cases. We want to know how you think about ruling on it. And all the questions asked of you, none of them thus far have had anything to do with 32,000 pages of documents. They have to do with probably, if you added up all the speeches you gave, it would give us insight into how you think. Maybe there's 1,000, maybe there's 500, maybe there's 1,200 pages, but that's what we're talking about. And I know you know that. I just want to make sure that the public doesn't think you have to go back and look over 32,000 pages of documents and how to analyze it. That's sort of the Wall Street Journal argument. This has nothing to do with 32,000 pages of documents. Now, Judge, I want to see if I can come away from this round of questions with a better understanding of the method, not the result, the method that you would apply to interpreting the very difficult phrases in the Constitution, which have been phrases that have been matters of contention for 200 years or more, and when interpreted, have sent the country off in one direction or another. Now, you'd be pleased to know I don't want to know anything about abortion. I don't want to know how you think about abortion. I don't want to know whether you ever thought about abortion. I don't want to know whether you ever even discussed it. I don't want to know whether you talked about it in your sleep. I don't want to know anything about abortion. I mean that sincerely, because I don't want that red herring, in my case at least, to detract from what I'm just trying to find out here, is how do you think about these things? When you and I talked on Tuesday, you said, and I quote in this hearing, "I don't see a role for the use of natural law in constitutional adjudication. My interest in exploring natural law and natural rights was purely in the context of political theory." Now that struck me as something different than you said in many speeches, and I gave you some of those speeches yesterday so that you'd know what I wanted to talk about today, and you know I want to talk about this subject with you so I can understand it better. So let's start with what you not said in the speeches, but what you told the committee so far about whether natural law does or does not impact on the Constitution. Yesterday, you told us that the framers of the Constitution, quote, subscribed to the notion of natural law, end of quote. But you emphasized that any such belief, any belief held by the framers based on natural law, had to be reduced to positive law, that is, put in the Constitution for it to have any effect or impact on adjudication. The framers, you said, sometimes, quote, reduced to positive law in the Constitution aspects of life principles they believed in. For example, liberty. But when it's in the Constitution, it's no longer natural rights. It is a constitutional right, and that's an important point. So as I heard that statement, I began to think I'm beginning to understand your thinking on this, but I want to be sure. Do you recall saying that yesterday?
I generally recollect that.
And is that a fair rendition?
I think it is.
Then you went on to say, and I quote, "Positive law is our Constitution. And when we look at constitutional adjudication, we look at that document." Let me have a copy of the Constitution, please. So it is purely positive law. It's purely that Constitution, this document. When you as a judge are interpreting it, the fact that the framers based the Constitution, may or may not have based the Constitution on natural law, and you and I think they did,
Yeah.
that does not impact on adjudication unless it was reduced to writing in the Constitution. And then it's positive law. That's what you mean by positive law, right?
That's right.
Now, and so it's purely positive law that you as a judge look to in order to decide a case. Is that right?
I think I indicated in later testimony, and this is an important point, and it's one, as I read your op-ed piece, it's one that I think you ask in a different way. You say, is it rigid, or is this concept of natural law rigid? For me, that question would be, is the concept of liberty rigid?
I see.
And in our constitutional tradition, the concept of liberty is a concept that has been flexible. It's one that has been adjudicated over time, looking at history, tradition, of course, starting with what the founding fathers thought of the concept of liberty, but not ending there.
Okay. I'm beginning to understand it. So, natural law informed the notion of liberty. You and I have both read, because of our backgrounds, I suspect, we both read, I won't get into Aquinas and Augustine and all of that, but Locke looked back to the concept of natural law as an evolving notion. Montesquieu talked about it. Jefferson understood it. He was in Paris. He was probably the only one that fully understood it. But others who were there writing the Constitution, they talked about it. They had what they wrote, both the Declaration, as you say in other places, and in the Constitution. They reduced these broad notions of natural law, the natural rights of man, to this document. Now, you say that they put some of these natural law principles in the document, and words like liberty you just mentioned, you indicate that once liberty was in the Constitution, it becomes positive law. But now comes the hard question, as you and I both know. A judge has to define what liberty means. Now, how does a judge know what the ambiguous term liberty means in the Constitution? And I want to start with a key term in the Constitution, one that protects the right of privacy and many other rights. Yeah. And that's the word you've mentioned yesterday, you mentioned again here today, liberty. Yesterday you told the committee, our founders and our drafters did believe in natural law, in addition to whatever else philosophers they had, and I think they acted to some extent on those beliefs in drafting portions of the Constitution. For example, the concept of liberty in the 14th Amendment. So the concept of natural law, liberty, is embodied, you say, and I agree with you, in the 14th Amendment. You also then said, to understand what the framers meant and what they were trying to do, it's important to go back and attempt to understand what they believed, just as we do when we attempt to interpret a statute that is drafted by this body, to get your understanding, end of quote. Now, as I understand this, Judge, while you reject any direct application of natural law, that is you sitting there and saying, I think natural law means, therefore, I rule. Even though you reject the direct application of natural law in constitutional adjudication, you would use natural law to understand what the framers had in mind when they interpreted these broad notions. Isn't that correct?
Not quite, Senator.
Okay.
Let me make 2 points there. The framers' view of the principle of liberty is the important point.
Right. Okay.
Whatever natural law is separate and apart. The important point is, what did the framers think they were doing? What were their views?
Gotcha.
The second point is this. That is only a part of what we conceive of this notion in our society. The world didn't stop with the framers. The concept of liberty wasn't self-defining at that point.
Right.
And that's why I think it's important, as I've indicated, that you then look at the rest of the history and tradition of our country.
I agree with you completely, which may worry you, but I agree with you completely. Now, as a matter of fact, you use that argument to take on the original intent people in some of your speeches. You basically say, hey, you folks who just go original intent and are pure positivists, you got to look at intent, real intent, and real intent of these guys is not just static, it goes on, it's informed by changes in time, and also you got to understand, as I understand you, that they used the word liberty because they believed it to be a natural right of man. I mean, to be specific, you say, and that's what you said here, our founders believed in natural law, but they reduced the natural law to positive law. And one of those concepts in natural law they reduced was liberty to positive law, because the word liberty appears in the Constitution, in the 14th Amendment in particular. Now, in a speech before the Pacific Research Institute, which I gave you yesterday, you praised the opinion of Justice Scalia in Morrison v. Olson. That's the case where the Supreme Court upheld, as you know, 7-1, the right of the Congress to say there can be a special prosecutor like Walsh, like the Iran-Contra. It wasn't about Iran-Contra, but the special prosecutor. But Scalia filed a lone dissent, and you praised his dissent, and you said the following: Justice Scalia's remarkable dissent in Morrison points the way toward the correct principles and ideas. He indicates how, again, we might relate natural rights to democratic self-government and thus protect the regime of individual rights. You go on to say that that principle means that the principles and ideas indicated by the opinion and the Massachusetts Bill of Rights, which you quote, refers to, quote, and you're referring now, you say, summarizes well the tie between natural rights and limited government. Beyond historical circumstances, sociological conditions, and class bias, natural rights constitutes an objective basis for good government. So the American founders saw it, and so should we. But we don't. Try talking to a Justice Department attorney about natural rights. And when you mention the venerable term, they assume that you're an activist, that you want an activist court along the lines of Mr. Justice Brennan. That such an assumption must be fought reveals the extent to which the term natural rights has been corrupted and misunderstood, and not only among the class of conservative sophisticates in Washington. Now, I don't know any other way to read this passage than to conclude that you believe that natural law and natural rights should help judges decide constitutional decisions.
No, Senator. I've said that I've repeated that continually here.
I know, but
Senator,
it doesn't jibe.
But, Senator, I was speaking as a chairman of EEOC, and let me explain to you what my interests were. I have under oath in my confirmation for the Court of Appeals and for this court tried to explain as clearly as I possibly could what I was attempting to do. Speech after speech, I talked about the ideals and the first principles of this country, the notion that we have three branches so that they can be in tension and not impede on the individual. That's what this case is about. At bottom, the case is about an individual who could be, in some way, whose rights could be impeded by an individual who's not accountable to one of the political branches. That was the sole point.
I understand the point.
I have not, in any speech, said that we should adjudicate cases by directly appealing to natural law.
What was Scalia doing?
Senator, I think
adjudicating a case, wasn't he?
He was pointing out the relationship, the purpose of the relationship among the branches.
Right, but Judge, wasn't the reason he was pointing it out, if we need be, we'll spend all day Friday on this, wasn't the reason he was pointing this out because he wanted the case adjudicated, decided in a way differently than the 7 justices who decided it in favor of the existence of, the constitutionality of. He was adjudicating. Now, what is this? It seems like we're engaged in a little bit of sophistry here. What, wasn't he adjudicating a case?
He was adjudicating a case. I am only pointing to, as I say here, the concern that I had between the relationships in the branches. If, Senator, I, as a sitting federal judge, had written this speech, considering the fact that I adjudicate cases as a sitting federal judge, and did not draw a clean distinction between a speech that is talking generally about the protection of individuals, then I think you have a very valid point.
What did Scalia do, Judge? Didn't Scalia do just what you said? Scalia applied natural rights in making a decision before the Supreme Court of the United States of America. You say that's what he did, and you recommend to everyone else, look at what he did.
Senator,
it's a good thing.
Senator, I beg to differ.
Okay.
I have attempted in good faith and under oath twice to make clear that I don't think that an appeal and a direct appeal to natural law is a part of adjudicating cases. Now, the point that I was attempting to make here, as I indicated to you, is simply, he indicates how, again, we might relate natural rights to democratic self-government.
Right. That's what he was doing.
Relate. I didn't say adjudicate cases. Senator, I am interested. I was interested in the notion that you have the 3 branches of government.
Right.
And you have an individual. Now, let me give you an example of my point, talking about the ideal. I think that we agree that the ideal that all men are created equal is an ideal. It is certainly one that was in our Declaration.
Is it based on natural rights?
It was based on our founders' belief in natural rights.
Right.
But slavery existed even as that ideal existed.
Right.
That did not mean that slavery was right or comported with that ideal. It did not mean that you could end slavery without a constitutional amendment.
Agreed. That's the point, Judge. The point is, you say, our founders looked to natural law to inform what they put in the Constitution. But it doesn't matter. The fact they said all men are created equal didn't mean anything until the 13th and 14th Amendments to stop slavery. But once they put it in, this natural law principle, in 1866, it became part of the law. Now, we have to treat it as law. But because it is uncertain what that means, for example, does all men mean all women? That's what the 14th Amendment was about. We've concluded it does. Because we don't know what it means, because it's broad and ennobling, we have to go back, you said, and look at the framers and what they meant.
As a starting point.
As a starting point. So at least, Judge, will you not acknowledge you conclude that natural law indirectly impacts upon what you think a phrase in the Constitution means?
To the extent that it to the extent that the framers' beliefs comport with that.
What the framers thought natural law meant.
The important point is what the framers believe. For example, I think I said I'm trying to find the precise statement here.
Take your time. We have a lot of time. Really, take your time. Pull that clock.
I think in referring in the speech toward a plain reading of the Constitution,
I read it. Good
I
speech.
indicate that Harlan's dissent relies on his understanding of the founders' arguments,
Right.
not some direct appeal to any broad law out there that we don't know.
But how did he figure out what the founders meant by natural law?
Again, I think, Senator, you look at the debates, you look at whatever it was that Harlan had available to him. There's not an explicit direct reliance on anything other than what he could find the founders meant.
Right.
How do we look at history and tradition? How do we determine how our country has advanced and grown? It's a very difficult enterprise. It's an amorphous process at times, but it's an important process.
Well, that's the one we're trying to find out you used, Judge. For example, before I leave the Pacific Research speech, let me digress for just a moment. In that speech you said, and I quote, "Conservative heroes such as the Chief Justice failed not only conservatives but all Americans in the most important case," that's Morrison, "the most important case since Brown versus the Board of Education. I refer, of course, to the independent counsel case of Morrison." And you said the Morrison case upheld the constitutionality of independent counsel, it should have, which did uphold it. You thought Scalia was right that it shouldn't have upholded it. Now, Judge, why is a case upholding the legality of an independent counsel the most important case since Brown versus the board?
Senator,
A lot of important cases, Baker and New York Times and the Pentagon family.
Well,
why is that one? Just out of curiosity.
Well, the reason that I used that approach was it was, for most people, it had to do with an obscure point on the separation of powers. So that doesn't exactly excite people in an audience. The point was, though, that I was trying to indicate to them is that when we address cases involving the structure of our government, there is a subsequent impact, or it could have a direct impact on individuals. And I think that's the point that I made in the speech, and that was the central part of the speech. It was not an exegesis of the Supreme Court opinion itself, but how it affected the relationship of the government to individuals. And again, it's a point that I'd have to make again, Senator, that underscores much of the discussion of natural law. It has to be understood that I took on this endeavor as the chairman of EEOC because of my general view that the last great person who was able to inspire our country toward an ideal was Martin Luther King. And the notions of the poor treatment of people in our society.
I agree with you, Judge.
But it was not an effort, as I indicated in my confirmation hearings for the Court of Appeals, to establish a constitutional philosophy,
Judge,
to adjudicate cases.
Well, Judge, I don't know how you can possibly say that, since you say the framers, let's just stick to liberty. The framers put liberty in the Constitution because they thought it was a natural law principle. They put it in the Constitution. It became positive law. Nobody knows what liberty means for certain. So judges today have to go back and look what the framers meant by it. How you cannot examine what their view of natural law was in order to know what they meant is beyond me, but...
Well, that's the point. We agree there.
Okay, we agree. All right, now...
That's for starters, though.
Okay, so you're going to apply, at least in part, the framers' notion of original intent, of natural law, right?
As a part of the inquiry.
As a part, okay. Now, so how do we know what the framers of the 14th Amendment had in mind? when they said liberty? How do we know they had the same version of natural law in mind as, say, the framers in 1789 when they talked about all men are created equal in the Declaration and then enshrine that principle in the Constitution later? How do we know?
Well, Senator, again, I have not used or interpreted that provision in the context of adjudication, but the important starting point has to be with the debates that they were involved in and their statements surrounding that debate.
Yeah, and the debates, don't they use phrases like God-given rights and they came from God, and don't they use those phrases? I read them.
But let me move forward. I also indicated that the concept doesn't stop there. It's not frozen in time. Our notions of what liberty means evolves with the country. It moves with our history and our tradition.
All right, well, Judge, if tradition and history, what happens if the tradition and history conflicts with what you and I would believe to be the natural law, meaning that the founders had at the time? Even though it's been reduced to positive law. The word liberty was reduced to positive law in 1866. Tradition and history demonstrated when that happened, for example, women didn't have the right to vote. Women were not allowed to be everything from lawyers to whatever. So you look at tradition and history and you conclude, obviously, they didn't have women in mind, yet when you look at the natural law principle they had in mind, they must have had women in mind when they talk about all men and the rights of individuals. Now, when they conflict, natural law, underpinning of the founders or the framer of that amendment's notion, and history, which do you choose?
Senator, let me make that point, or let me address that by saying this. The concept is a broad concept.
Right.
And
that's the problem.
That's it. But maybe that's one of the reasons the founders used that concept. It is one that evolves over time. It is one, I don't think that they could have determined in 1866 what the term in its totality would mean for the future.
I see.
But in constitutional adjudication, what the courts have attempted to do is to look at the ideals, to look at the values that we share as a culture, and those values and ideals have evolved in that specific provision, has evolved over time.
In a lot of other provisions, they've evolved too, Judge.
Well, but in that provision,
sure,
it's
in
evolved.
liberty. Let's just stick to the liberty clause. They've evolved. Now, some argue, a number of very distinguished jurists before us argued, that evolution of those views should be bound by the history and their tradition, and Justice Scalia, who you quote often, fundamentally disagrees with your view about going back and looking at the natural law tradition. You said, for example, yesterday, that there's a right to privacy in the 14th Amendment, and it was made clear that this is a marital right to privacy. Now, Judge, I assume you find that right in the Liberty Clause, this right to privacy.
The liberty component of the Due Process Clause.
Right. Now, let me ask you this. If I can move along, in light of my time here, the discussion of this question yesterday about right to privacy. Yesterday with Senator Leahy, you told the committee, I quote, "I believe the approach that Justice Harlan took in Poe versus Ullman and have reaffirmed again in Griswold in determining the right to privacy was the appropriate way to go." Is that correct?
That's what I said, I believe, yesterday.
Now, I find this still harder to understand in light of the fact that Justice Harlan in Poe relied specifically on natural law. Let me read the quote to you. He says, "It is not the particular enumeration of rights in the first 8 amendments that spells out the reach of the 14th Amendment due process, but rather it was suggested in another context, long before the adoption of that amendment," meaning the 14th Amendment. "It is those concepts which are considered to embrace rights, quote, subquote, which are fundamental and which belong to all citizens of a free government." And he's quoting the Corfield case there. Now, Justice Harlan reaches his judgment based on natural law. And he quotes the Corfield case, which I might add, Judge, as late as, this isn't something new, as late as 1985 in the Rehnquist court. They quote the Corfield case as well. So you say, this is what confuses me, you say natural law is no part of adjudication of a case. You rely on, let me just finish, and you can tell me how I'm wrong. You rely on Justice Harlan in Poe as the rationale as to how you find a right to privacy in the 14th Amendment. Justice Harlan adjudicates that there is a right because it is a natural right. And you say natural right has no part of the adjudicating process of whether or not the word liberty means A, B, or C, or any other provision of the Constitution that we have difficulty understanding means anything. Explain that to me.
You missed an important point, maybe I'm not making myself as clear as I could be. What I said was this, that there is no independent appeal to natural law.
What do you call Poe?
What one does is one appeals to the drafters' view of what they were doing, and they believed in natural law. What were their beliefs? And one moves forward in time.
Let me stop you there for a second so I understand now, okay? I'm not trying to confuse you, I'm trying to understand. The drafters had different views of natural law. You and I both know that. Some agreed with the Thomistic view, not Thomas, who's been up for, not you, Thomas Aquinas. Some agree with the Thomistic view. The natural law is not revealed all at once, but natural law is a process that reasonable men, reasoning together over time, will determine what it is. Others believed, more in the Augustine tradition, he didn't call it natural law, that it's revealed. God just sent these down on high, and some people believe that it's even de fide doctrine, you know, boom, infallibility. This is the law. They had different views. Now you're saying you've got to go back and look at what their view of natural law is. How do you determine which view it was?
Well, I think it's difficult in any enterprise when you attempt to determine what other people were trying to do. But I think the important point that has to be made...
It's subjective, isn't it, ultimately?
It's an important point, and it's a difficult point, and it's a difficult determination. Just as it's difficult to determine after that how our tradition and our history and our culture evolves, and what are the underlying values. I think that that is the point that Justice Harlan and others have attempted to make, that it's not to constrain the development of rights that you would want this adjudication being tethered to our history and tradition, but rather to restrain judges.
Judge, Justice Harlan had no problem. He didn't have your problem, this torturous logic, which I think borders on, well anyway, this torturous logic. He had no problem. He went straight to the heart of it in his dissent. He said, you don't look to any one of the amendments to inform, or all of the amendments to inform the 14th. I, Harlan, I don't have that problem, he says to the world. I go straight to natural law. And by the way, I'm not the first one to do that. In Corfield, they did that. And you say, you base your conception of privacy in the Liberty Clause based on Harlan in Poe. And now you're telling me that you don't think natural law plays... He didn't fool around. He went right to the heart of the matter.
What I said was, again, Senator, is that one goes to what the founders and the drafters believe.
And he believed...
You don't just, as you indicated, that there were competing notions of natural law. I think it is an important, though difficult, inquiry, and that it is one that the court undertakes, as well as the subsequent development and expansion and growth of the liberty component of the Due Process Clause through referring to history and tradition.
All right, well, Judge, I don't know why you're so afraid to deal with this natural law thing. I mean, I don't see how any reasonable person can conclude that natural law does not impact upon adjudication of a case if you're a judge, if you acknowledge that you have to go back and look at what the founders meant by natural law, and then, at least in part, have that play a part in the adjudication of
But
the
I am
outcome.
admitting that.
Pardon me?
I am admitting that.
Oh, you are admitting that? Oh,
And I have. I said to the
okay,
extent
good.
that
So natural law does impact on
framers-
the adjudication
to the
of
ex-
cases.
to the extent that the framers
Good.
believed.
Good. But we both admit, you looking at the framer and me looking at the framers, we may come to two different conclusions of what they meant by natural law.
But we also agree that the provisions that they chose were broad provisions that adjudicating through our history and tradition, using our history and tradition, evolved.
All right, let me move on. I'm trying to get through this quickly as I can here. Judge, if you're confirmed, you would go about interpreting the Constitution prior to Tuesday, I thought, and now I understand, with natural law at least playing some part as you described it. Now, that still leaves me in the dark about how you'd interpret the broad principles of the Constitution in terms of what kind of natural law informed our founders, and as to whether the right of privacy protects certain family and personal decisions or it doesn't. As you point out, after all, the 14th Amendment is broadly phrased. It speaks of liberty and of due process. Now, the court has used this broad language in the past, the court, Supreme Court, not the founders, to recognize that certain types of personal decisions about marriage, child rearing, and family are fundamental to liberty. That's the phrase they use. That means that government must have an extraordinary, as you know, or compelling reason for interfering with the decisions. I'm not talking about abortion. I don't want to talk about abortion. I will answer no questions on abortion. All right? Now, do you agree that the right to marital and family privacy is a fundamental liberty?
Yes.
Now, let me ask you a second question. You have written a great deal about the rights of individuals as opposed to group, belonging to individuals, that human rights, natural rights, positive law rights apply to individuals, not to groups. And in fairness to you, you've done it almost always in the context of talking about civil rights as opposed to civil liberties. It doesn't mean exclusive of civil liberties, but you've made your point about affirmative action, quotas and other things through that mechanism. Now, am I correct in presuming that you believe that the right of privacy and the right to make decisions about procreation extend to single individuals as well as married couples? The right of privacy.
The privacy, the kind of intimate privacy that we're talking about, I think...
The right about specifically procreation.
But, yes, procreation that we're talking about, I think the court extended in Eisenstadt v. Baird to non-married individuals.
Well, that's a very skillful answer, Judge. Judge Souter, and I was not fully prepared when he gave me the answer. I am now. Judge Souter waltzed away from that by pointing out it was an equal protection case. So that I want to know from you, is this do single individuals, not married couples alone, have a right of privacy residing in the 14th Amendment Liberty Clause?
Senator, the courts have never decided that, and I don't know of a case that has decided that explicit point. Eisenstadt was, of course, decided as an equal protection case. And
not alone, but go on.
My answer to you is I cannot sit here and decide that. I don't know.
Why can't you? That case is an old case. I know of no challenge before the court on the use of contraceptives by an individual. I can see no reasonable prospect there's going to be any challenge. And Judge, I mean, are you telling me that may come before you? Is that the argument you're going to give me?
Well, I'm saying that I think that for a judge to sit here without the benefit of arguments and briefs, et cetera, and without the benefit of precedent,
Okay.
I don't think anyone could
Well,
decide
Judge,
that.
I think that is the most unartful dodge that I've heard, but let me go on. Judge, I think the decision in Eisenstadt, and so do I think most scholars, think it stands for a much broader principle beyond equal protection. Let me read to you from Eisenstadt, in the majority opinion. The marital couple is not an independent entity with a mind and a heart of its own, but an association of two individuals, each with a separate intellectual and emotional makeup. If the right of privacy means anything, it is the right of the individual, married or single. Stop here. Same point you make about civil rights. Individual. Back to the quote. If the right of privacy means anything, it is the right of the individual, married or single, to be free from unwarranted government intrusions into matters so fundamentally affecting a person as the decision whether to bear or beget a child. Many Supreme Court cases since then have been decided using the ruling in 1972 that I referred to, using this basic principle. So for the time being, let's put aside equal protection again, Judge, and focus on the more sweeping question of the right of privacy. And I ask you again, do you think that single people have a right to privacy anchored in the Liberty Clause of the 14th Amendment?
I think my answer to that, Senator, is similar to my previous answer, and it is this, that the court has found such a right of privacy to exist in Eisenstadt v. Baird, and I do not have a quarrel with that decision.
So you don't quarrel with the quote I just read to you?
I don't quarrel with the decision in Eisenstadt v. Baird.
That's not the question I'm asking you, Judge. Do you quarrel with the quote that I read you from the majority opinion?
I don't quarrel with the quote.
Do you agree with the quote? Let me ask you that way.
Well, let me...
This is getting more like a debate than it is getting information.
The important point that I'm trying to make, Senator, is that the case was decided on equal protection basis.
I understand that.
I do not quarrel with the value that you're discussing. I do not quarrel with the result in the case.
Judge, I'm not looking for your values because I know you're not going to impose them on us. I'm not looking for your judgment on the case as whether it was equal protection. I'm asking you whether the principle that I read to you, which has in fact been pointed to and relied upon in other cases, is a constitutional principle with which you agree, which is that single people have the same right of privacy, not equal protection, privacy, as married people on the issue of procreation.
I think that the court has so found, and I agree with that.
All right. Now, let me ask you this. Are there... my time's going real well, Senator. Thank you. I don't have any idea. Just like you, I'm looking at that little clock, and when it gets...
Who sets this clock? Who keeps this clock?
Some impartial person that works for me, Senator, back there.
I was afraid of that.
That's what I thought. Now, you said that the privacy of right of married couples is fundamental, and as I understand it now, you told me, correct me if I'm wrong, that the privacy right of an individual on procreation is fundamental. Is that right?
I think that's consistent. That's consistent with what I said, and I think consistent with what the court held in Baird v. Eisenstadt.
All right.
Eisenstadt v. Baird.
Just so we don't have any problem here, I think your friends think you're getting in trouble, and they'd like me to stop. So
No,
what I will
no.
do is I will stop now.
Go ahead.
Well, Chairman Danforth suggests we can go forward. But if you would, if we've gone over the time of a half an hour, we should stop. And if not, I'd be delighted to keep going, because I'd like to now talk about another phrase in the Constitution.
Do it like that because when I started this hearing, I emphasized the issue of fairness, and that's what this is. Every
If
one of us.
I have gone over 20 minutes, half an hour, I should stop.
I can assure you, you have. You've gone about 35 or 40 minutes.
All right, if I've gone 5 minutes over, then I stop. Thank you very, very much. And I want to assure you, there's no plot back there, Judge, notwithstanding what my friends may think. But thank you very much. I think I've learned a lot more about what you think, and I want to come back, and just so you know, so there's no surprise, I'm going to come back and talk about other provisions of the Constitution which we don't understand the exact meaning of. I don't mean just we, the universe of lawyers. Thank you very much. I yield now to the distinguished senator from South Carolina, and if I've gone over any time at all, add that time to the senator from South Carolina's time. Oh, I'm sorry. It's been suggested that that it'd be appropriate time for there be a 10-minute break. We'll recess for 10 minutes.
You from 19.
Judge, welcome back. I want to make clear for the record, I was not referring to, when I said your supporters, I was not referring to the distinguished senator from Missouri or anyone from the White House or your family or you or your friends. I was referring to the intramural scuffle occasionally we get into here. And I want to make it further clear, there was no need for, we had agreed before we began that we'd break after 2 people. I wasn't suggesting, quote, you needed a break because of the relentless questioning. That was no part of it. It was the intramural scuffle that was going on here, which is all intramural scuffles are ended here because there's no problem. And as is always the case, if the senator from, if I went over, and apparently I did go over, the senator from South Carolina and or any one of my colleagues on either side, I don't ever recall cutting anyone off when they've gone 35 minutes if they were in the line of questioning, and I won't do it now. They can have as much time as they want, and we'll break after 2 more for lunch, and we'll move on from there. I now yield to my friend. Yes.
Too, I want to clarify that I understand that the time and the lapse or the failure to terminate was totally inadvertent, and I want to state that. I understand that was an error. It did occur, but it certainly wasn't anything.
I think what happened was, remember when you were going through your book, I turned and said, hold the clock. And what happened was this clock is not what you'd call, the Navy Department would not use it for its instrumentation purposes. And that's what happened. We did go over 5 minutes. We're all squared away. 18 minutes?
That's what I understood, 48 minutes, what I heard. 48 minutes, that's what it said.
Well, Senator, you can have 53 minutes if you'd like. I yield to my friend.
I don't care if anymore, we'll just cut yours next time.
All right, here we go. The senator from South Carolina.